Hi everyone, Keith Carlson here from Carlson and Jayakumar, providing you with another one of our video updates of some decisions out of California Courts of Appeal and the Ninth Circuit. Hope you all had a good Thanksgiving weekend. The shortened week provided us with a few less cases last week, so I'm going to combine a bit of the end of November and early December cases. First up, some healthcare retaliation and negligence matters that made it through the California Courts of Appeal. Slone versus El Centro Regional Medical Centers. First up, it involved a non-board certified surgeon with privileges at El Centro Regional Medical Center. The center suspended him for not doing some of his medical records. He then turned around and sued for a Health and Safety Code Section 1278.5 retaliation claim, saying he had made patient complaints and that was the reason for the suspension, which was later morphed into a separation from the hospital. The trial court ruled for the center, finding neither retaliation nor damages, and the doctor did not make the record clear where the specific error in the record was when he was bringing it to the Court of Appeal. So the Court of Appeals affirmed the lower court's ruling. Takeaway quote there was, in order to demonstrate error, an appellant must supply the reviewing court with some cogent argument supported by legal analysis and citation to the record. Rather than scour the record unguided, we may decide that the appellant has waived a point urged on appeal when it is not supported by accurate citations to the record. So that's the Court of Appeal letting all appellants out there know we need a real clear citation in the record to what the underlying error was. The doctor didn't have that in that case, and the hospital prevailed. Another matter in the employment-related context that went up, employment and healthcare context that went up to the Court of Appeal was Murphy v. City of Petaluma. There, a car accident victim repeatedly told the paramedics she did not need medical assistance and was not injured. They warned her, you might be seriously injured and you should go to the hospital and see a physician. Maybe the symptoms aren't manifested yet. She declined again, and the paramedics ultimately left the scene. She later, unfortunately, had a stroke and then sued the paramedics for negligence in not assessing her condition and not transporting her to the hospital. The paramedics won on summary judgment, and the Court of Appeals affirmed that victory, indicating there is no assumed duty of care when the patient refuses care. Next, we have a couple of arbitration cases in the courts that were making their way through the last couple of weeks. Trujillo versus JM Manufacturing Co. Unusual twist on the recent late payment of arbitration fees cases. You might remember we've talked about those in past weeks, where the courts are coming down really hard on defendants who are not paying timely fees. Here, the parties stipulated arbitration after beginning litigation. The defendant employer defending a sexual and gender discrimination and harassment case was late on one of four payments owed to the arbitrator throughout the course of a year. The trial court received a motion from the plaintiff trying to move it back to Superior Court and affirmed it and granted that motion. But the appellate court reversed the trial court because CCP section 1281.98 doesn't apply to post-dispute stipulations, only pre-dispute agreements to arbitrate. So because the parties had agreed to arbitration after initiating litigation, the late payment did not subject them to a trip back to the Superior Court, which is what all of the cases we've been seeing in the last couple of months have been doing. Gonzalez versus Nowhere Beverly Hills LLC is another interesting arbitration matter. There, the plaintiff worked at one of a number of interrelated markets in the Los Angeles area, had signed an arbitration agreement before beginning work for one of the defendant markets. He sued for labor code violations and said the related markets, of which there were something like 10, were joint employers. Defendants moved to compel arbitration, but only plaintiff's specific market was granted the order to compel arbitration. The others were denied and were going to be in Superior Court. The Court of Appeal ruled, however, that he was stopped equitably from avoiding arbitration with the other entities because the claims were intertwined. So his joint employment theory essentially required arbitration with all of them. Last up, there was an abortion and free speech case, Planned Parenthood versus Labrador out of the Ninth Circuit, enjoining Idaho's Attorney General from enforcing Idaho's criminal abortion law. The plaintiffs argued the law prevented free speech as it wouldn't allow doctors to tell patients information about abortion services out of Idaho. The Ninth Circuit agreed with that and has enjoined application of that statute. That's all for the end of November and the beginning of December. We hope you're having a good start to your holiday season, and please let us know if you need any more information. Thanks so much. Bye-bye.